Thank you for tuning into Bond Court. I want to continue posting Bond Court every night on YouTube, but the viewership and engagement on my channel has fallen off a cliff. I would greatly appreciate your help by hitting the like button and leaving a comment on my videos. Thank you and enjoy the show.
Good morning, Your Honor. This is Laura Royo, State Certified Interpreter and previously sworn.
Hi, Ms. Royos. Good to speak to you again. We've got 4 here in Orange County that need the services of the Spanish interpreter.
Yes, Your Honor. 1 second while I establish connection with
All right, thank you.
podium. Connection is established.
All right, this is Diana Gonzalez Diaz. Case number is 2022 CF 10311AO. It's 4 counts. 1 count of battery domestic violence, 1 count battery by strangulation, 1 count of tampering with the witness to hinder communication to law enforcement, and 1 count of robbery by sudden snatching. Court will appoint the Office of the Public Defender to represent you. Court's reviewed the arrest affidavit, does find probable cause as to counts 1, 2, and 3, finds no probable cause that relates to count 4, that there's no allegations that the intent was to permanently deprive the victim of the phone. So you'll be ROR'd as to count 4. With regards to count 1, bond will be set at $100. With regards to count 2, bond will be set at $500. Regards to count 3, bond will be set at $100. Special conditions of your bond: that you have no contact with the alleged victim in this case, that you do not return to the residence where this is alleged to have occurred, and that you possess no weapons. If you need to go back to the residence one time, you may do so under the accompaniment of law enforcement to retrieve personal belongings. After that, you got to find somewhere else to stay until further order of the court. No contact with the victim means no contact. No text messages, no emails, no Facebook, no communication through third parties. All right, thank you, ma'am. All right, sir. What's your name?
Francisco Javier Dominguez.
Francisco Javier Dominguez.
All right, Mr. Dominguez, you're here in case 2022 CF 10304. It's 3 counts. First count is aggravated battery. Second count, aggravated assault with a deadly weapon. And the third count, simple battery. The court's reviewed the arrest affidavit, does find probable cause as to each count. I'll appoint the Office of the Public Defender to represent you. Set bond on count 1 at $3,500, state the bond. Count 2 will set bond at $250. And count 3 will set bond at $100. Condition of your bond is that you have no contact with any of the alleged victims. No contact means no contact. No emails, no text messages, no contact through third parties. Also order that you do not return to the residence where this is alleged to have occurred. If you need to return once to get some personal belongings, you may do so under the accompaniment of law enforcement. After you get your personal belongings, you got to find somewhere else to stay. Also order that you possess no weapons. That includes knives, firearms, ammunition, flamethrowers, grenades, anything. All right, sir. Have a good day.
Gracias.
Thank you.
All right, sir. What's your name?
Amoy Garcia Diaz.
Amoy Garcia Rivera.
No, Diaz.
I'm sorry, Your Honor, I'm going to ask him to repeat.
Amoy Garcia Diaz.
Amoy Garcia Diaz.
All right, Mr. Diaz, you are here in case 2022 CF 7195AO. It's 4 counts. First count is robbery, armed with a deadly weapon. Second count is aggravated assault with a deadly weapon. Third is resisting a merchant. And fourth is petty theft. This was pursuant to a arrest warrant. So a probable cause determination as to each count has been previously made. Is count 1 a PBL state?
I can have just one moment, Your Honor.
I think it is. So the state, I'm going to go ahead and point the Office of the Public Defender to represent you. Count one of the complaint alleges a crime that in the state of Florida might be punishable by life. In those instances, people charged with those offenses are not necessarily entitled to a bond.
Yes, Your Honor.
And count 2 came in no bond as well. I'm not sure if that one's, I was pretty sure about count 1. What about count 2?
I will double check that one as well.
It's just an ag assault with a firearm. Is that
I
correct?
guess all with a deadly weapon.
Yeah, it's an F3, so it's not.
Yeah,
a
I didn't think so.
Correct.
But it came in no bond, so I just wanted to double check. All right. With regards to count 1, we're going to stay the bond at none. With regards to count 2, set bond at $5,000. Regards to count 3 and 4, bond will be set at $100. As conditions of the bond, you are to have no contact with the alleged victim, and you're not to return to the scene where this is alleged to have occurred. You're also to possess no weapons. No contact means no contact. No text messages, emails, or communication through third parties. Good luck to you, sir.
May I say something?
Sir, I've appointed an attorney to represent you. Anything you say can and will be used against you. You have the right to remain silent.
Okay.
The purpose of today's hearing is just to establish conditions of release. Given the nature of your charges, I'm not allowed to give legal advice. So consider this just practical advice. I'd be very cautious about talking about the facts of your case. Other than that, we're done for today.
Oh, sorry.
No, it's okay. I just don't want you to say something that may come back to bite you, okay?
No, okay.
Yeah.
Sorry.
That's okay.
Okay.
All right, thank you.
And Judge, I have a probable cause challenge from this case coming up.
I don't have the affidavit. It was,
There's a warrant and then there's also a no valid, and I would only argue as to the no valid.
okay. All right, sir, what's your name?
I'm sorry, the interpreter couldn't hear him.
Perez Sanchez Emmanuel. Perez Sanchez Emmanuel.
Perez, Sanchez, Emmanuel.
Mhm.
All right, sir, you're here on a warrant for a failure to appear. The bond in that warrant is for $500. The court is going to stay that bond.
Mhm.
And you're also here on a new, yes, hold on. You're also here on a new law violation of operating a motor vehicle without a valid driver's license. I'll appoint the Office of the Public Defender to represent you. Your attorney's indicated there may be some argument as to probable cause in this case. I'm going to let her make that argument. Okay? Counsel, go ahead.
Yes, Your Honor. In the affidavit for the no valid driver's license charge, I didn't see that he ever confirmed that he didn't have a driver's license. There's nothing contained saying I ran it through FCIC or NCIC. And even just noting that if he had a warrant for a failure to appear for a no valid driver's license doesn't mean he didn't obtain one in the meantime.
Court tends to agree with counsel. Say, do you have any rebuttal as to that?
I do not, Your Honor.
All right, so the court finds no probable cause based on the arguments of counsel on the new law. So we'll ROR you as to that. Court will note what seems to be a pattern. We'll just order as a condition of your ROR that you do not drive or operate a motor vehicle without a valid driver's license. Right. Thank you, sir. And that's
Your Honor,
it.
may the interpreter have the case number?
Oh, yes, sorry. That case number is 2022 CT 2329 AO was
Thank
one of
you.
them. I don't know if we have a case number for the, yeah. The other 2022 CT 5012 AO.
Thank you, Your Honor. The interpreter will not be needed for anyone else, not even victims in the public.
Does anyone out there speak Spanish?
¿Hay alguien allá afuera que habla en español y requiere un intérprete?
Nope. All set. Thank you
Okay.
very much.
You're welcome. The interpreter will disconnect.
All right. Have a good rest of your day.
You too.
All right, sir. What's your name?
Adam Geltz.
All right, Mr. Geltz, you're here on 2 counts, 1 count of battery, domestic violence, 1 count of battery on a person 65 years of age of older. I'll appoint the Office of the Public Defender to represent you. The court's reviewed the arrest affidavit, does find there's probable cause. We'll set bond on count 1 at $1,000. Oh, I'm sorry. Sir, what's your name?
Theodore S. Geltz, Jr.
All right, Mr. Geltz, I've reviewed the arrest affidavit. It's my understanding you're an alleged victim in this case?
I'm the one that asked to have him removed from the house, yes.
Yeah, and that's what we're doing here today, so I thank you for showing up. In the cases where there's victims, we like to have input from them when determining appropriate conditions for release. So what we're gonna do today, he's entitled to a bond, I'm gonna set a bond, but with that bond, we can require some certain conditions. We can have no contact We can have no hostile contact. We can order that he not return to the residence. We can order that he consume no alcohol. So my question for you is, do you wish to have no contact with him or no hostile contact? Are you afraid of him?
No, sir, I'm not.
You're not afraid of him?
No, sir.
Do you wish to have contact with him?
Yes,
All right.
I'd like him to come home.
Yeah. So you have no problem with him returning to the residence?
Not at all.
All right.
If he abides by your wishes.
Well, the court's inclined to order, and the court's going to order that you consume no alcohol, okay? Based on the allegations that are in the arrest affidavit, that's going to be a condition of your release. If he's violating the conditions, Dad, he can be picked up for violating the conditions of his release, then you can be held no bond. At that point, you're not entitled to a bond. You understand that?
Yes, Your Honor.
All right. All right. So we're going to set bond on count one at $1,000. We'll set bond on count two at $100.
Sorry,
Yes.
could you repeat those again?
And then 100. I wrote them down.
So through a bail bondsman, it's typically 10%. If you want to pay cash, you can, but he's going to get a bond in accordance with the bond schedule. So the bond is $1,000 on count one, $100 on count two. Conditions of the bond are going to be that you have no hostile contact with either of the alleged victims in this case. And I'm going to ask your dad, you have the right to remain silent. Anything you say can and will be used against you. So I'm going to ask these questions to your dad because he's not the one that's charged with the crime, okay? Who is Amanda?
His wife.
Is she here?
No, sir, she's in church
Sorry.
with the children. It's where I wish I was.
No, I understand. Yeah. Is it your understanding that his wife would like no hostile contact as well, or does she desire no contact?
I think just no hostile contact.
All right, State, she's not here. Typically, if the victim's not here, we have to order no contact. Do you all live together, all of you?
No, sir, can I kind of explain what's
Yeah,
going on?
absolutely, please do.
His mother, my wife of 45 years, was killed in an automobile accident 3 weeks ago.
Okay.
So they offered to come stay with me.
Uh-huh.
His wife and the 2 children. They've been there for 3 weeks. But he's really struggling with losing his mother.
I understand.
So.
So where do they live usually?
I live West Orange County on Lake Avalon. He has a place in Yalaha in Lake County.
So the wife and kids are staying with you as well?
They have been, yes. They're up there now because her brother is the pastor at First Baptist of Umatilla, and that's where he attends church.
Okay. All right, State, any objection to no hostile contact based on the representations from there's 2 victims alleged in the affidavit. One of them's here. The other one's at church, but the one victim's represented that it's his understanding that the wife would desire no hostile contact as well.
No objection from the state.
Okay. So I'm going to order that you have no hostile contact with either of the alleged victims, your wife and your dad, and no hostile contact with the children because, they're living in the house too, okay? I'm also, as a condition of your bond, going to order that you consume no alcohol. With the understanding that your dad's here, he's heard this condition. I'm hoping he'll convey it to your wife. If you violate that condition, they can just pick up the phone and say you're drinking, and the cops come out there and your violation of your bond, and you can be picked up, brought in here, and sit in jail on no bond, okay? So as long as you understand that, I'm sorry to hear about your wife, sorry to hear about your mother, but, yeah, I understand. But, you're going to have to try to find a different way to deal with it. I know it's tough, easier said than done. But we can't have things like this happen. And obviously, I know you don't want that. I know your dad doesn't want it. So there's obviously an issue there. So let this kind of be a wake-up call, and hopefully we don't see you back here, okay? That being said, yeah, don't possess any weapons, firearms. Dad, if you have any weapons, firearms in the house, keep them locked and stored. If he has any, if you have any, you need to surrender those to law enforcement within 24 hours of your release.
He has possession of.
Well, if they're
Locked in his safe, I don't have the.
you're not to possess them, Dad. You can have weapons, but just
He
keep them
doesn't
locked
have
and
the
keep them away
combination.
from him, okay?
I do.
All right, sir, thank you.
Is that it?
Your Honor.
Judge,
That's it.
thank you.
Thank you. right, sir, what's your name? All right, Mr. Paul, you're here with one count of trespass as a designated construction site. I've reviewed the arrest affidavit. I do find there's probable cause. I'm going to appoint the Office of the Public Defender to represent you. Came in on a $1,000 bond. I'm going to set bond in this case at $250 in order that you do not return to the site where this was alleged to have occurred, okay? Like the gentleman before you, that's a condition of your bond. If you show up there and they pick you up there again, then it's a violation of conditions of release and you're not entitled to a bond. You understand? All right. Thank you, sir.
Your Honor, Sergeant Noella's mental health.
All right. I'll appoint the Office of the Public Defender to represent Ms. Sargent. I've reviewed the arrest affidavit. Or do you want to waive her appearance?
Yes, Your Honor.
All right. I reviewed the arrest affidavit and do find there is probable cause.
Your Honor, I'd ask
Yeah.
if she qualifies for mental health pretrial release. Could we see if she could?
I was going to say, if she does qualify for mental health pretrial release, the court would order her on mental health pretrial release. If she does not qualify for mental health pretrial release, the bond will be stayed at $1,500.
Thank you, Your Honor.
2,500, sorry. That's right. It's right there on the front. It's right on top. No. Other than the normal.
Your Honor, Byrd, Raina refused.
All right, I'll appoint the Office of the Public Defender to represent Raina Byrd.
We'll wait for appearance, Your Honor.
All right, her appearance has been waived. Reviewed the arrest affidavit. David, do find there is probable cause. Will set bond at $500, order that she not return to the Dollar General.
Your Honor, if I may be heard as to conditions of release.
Yes.
It looks like she has a history of Baker Acts and mental health issues. Would it be possible to either have her screened for mental health pretrial release or ROR her?
Yeah, we'll do the same. If she qualifies for mental health pretrial release, she should be released on mental health pretrial release. If she does, and a condition of that will be no return to the Dollar General. If she doesn't qualify for mental health pretrial release, do you know if she has a history of competency concerns or?
I just
just
noted, I think she might have been Baker Acted as a result of this case. I could be wrong, but I saw a Baker Act in her history. I don't think that she's had a competency evaluation, though.
Yeah, if she doesn't qualify, court has no objection to ROR, the condition that she not return to the Dollar General.
Thank you, Your Honor.
All right, sir, what's your name?
Thank you, Your Honor.
All right, sir, what is your name?
Marcus Robinson.
All right. Was he currently out on pretrial release? Is that, or no?
I was out yesterday on something, probation, and I had to finish some classes.
Okay, hold on one second. Well, today you're here on one count of petty theft retail that happened yesterday.
Yeah.
All right. Court's reviewed the affidavit, does find there's probable cause. I'll appoint the Office of the Public Defender to represent you.
Thank you.
So now I'm going to direct these questions to your attorney, okay? So I don't want you to say anything that, everything's being recorded, anything you say can and will be used against you, and you have the right to remain silent. Usually, if you have an attorney, it's a good idea to exercise that right, okay?
Yes, sir.
All right. Was he out on PTR, on something else?
I don't know, Your Honor. I can double check and see.
I'm learning how to read these face sheets too. So up here, does that pretrial release, does that mean he was out on PTR on the top right? Okay. Okay. What case number was that? For the for the case he was on probation for? Four six zero eight. AO. Okay. All right. Here's the thing. You're just placed on probation, as you understand. And I'm not asking you to say anything again. I'm just gonna listen for a second, okay? And that's no disrespect. I just don't want you to say something that's gonna get you in trouble, okay? You're just placed on probation. That was for a battery. If it had been for a petty theft or any other theft, I was gonna be inclined to revoke that bond or to find an on-view VOP and hold you no bond. I know that terms of probation in the charge that you pled to, it looks like it was a plea, right? All right. I know it requires some classes. Can't do those classes in jail. Another term of probation, regardless of the offense, is that you don't break the law. When you do, 99 times out of 100, you get picked up and you're held no bond. All right? And you sit in jail for 365 days, given what you were charged with. So an entire year, you open yourself up to be sitting in jail for 365 days on that on a violation of probation. Listen, I'm not going to revoke the bond today. Or I'm not going to find an on-view VOP. But you can bet the judge where this is assigned is going to catch wind of this. A warrant's probably going to get issued, and it'll be up to him whether there's a bond or not. In the meantime, I'm going to set bond on this case. I'm going to stay the bond at $250, order that you don't return. I would advise you, this isn't legal advice, this is just life advice. If you get out of jail on this, you're able to bond out. If you're able to bond out on this, you need to go, enroll in your classes, do everything that you can regards to your probation before they come and pick you up, because I'm telling you, they're going to come pick you up. And if you get picked up and you can show the court, I'm enrolled in my classes, I'm doing all this, I just had this one slip up, the odds of you being put back on probation are a little greater. If you get out again and break the law again, probation, myself, the judge where this is, you're on probation in front of, they're gonna quite quickly look at you and your history and your case and say, you know, this young man's just not amenable to probation. He just needs to sit in jail for a while. Okay? So I'm just telling you all that. I'm not gonna find an on view at this point. I don't know why. I probably should, but I'm not going to. I'm gonna set bond in your petty theft, $250, no return to the scene. If you bond out on this, again, you need to start making some significant steps on the case you're on probation before they pick you up, because I have a feeling they are going to pick you up on that soon. Okay? All right. Good luck.
Your Honor, Taylor Michael is mental health.
All right. I'll appoint the Office of the Public Defender to represent Mr. Taylor. It's city ordinance cases. I did review the affidavit, did find there's probable cause.
And due to him being mental health, Your Honor, would you consider mental health pretrial release or in the alternative ROR?
Yeah, based on the nature of the charges and the facts alleged in the affidavit, we'd also ask that if he be screened for mental health pretrial release, and if he qualifies, he be so released. 1 second. That he not return to the Family Dollar. If he doesn't qualify for mental health pretrial release, sorry, I'm speaking like the interpreter's still here. That he be ROR'd under the condition he not return to the Family Dollar. All right, sir, what's your name?
My name is Tyrone Anderson, sir.
All right, Mr. Henderson, you're here on one count of battery with one prior battery. That's a third-degree felony. Comes in as no bond. It was domestic in nature. There's no victim present. I'll appoint the Office of the Public Defender to represent you. I've reviewed the arrest affidavit. I do find that there is probable cause.
Yes, sir. But, sir, can I ask you a question?
Well, listen, I've appointed the Office of the Public Defender to represent you. Anything you say can and will be used against you. You have the right to remain silent. When you have an attorney, even when you don't have an attorney, it's typically a good idea to exercise that right. Today's just your first appearance. We're just here to set conditions of release. In your case, you also have an out-of-state warrant with no bond, or out-of-county warrant with no bond, for a violation of probation. Court's going to stay the bond on the violation of probation at none. So whatever county that's holding you, what is it? Brevard?
Yes, sir.
Brevard County is probably going to come to get you on that VOP.
Yes, sir.
I am going to give you a bond on the battery,
Yes, sir.
$500.
Yes, sir.
Order that you have no contact with the alleged victim. She's not here. That you do not return to the scene where this was alleged to occur. I understand it was a hotel, but you can't go back there.
Yes, sir.
You possess no weapons, firearms, ammunition, no weapons whatsoever.
Yes, sir.
That if you have any weapons, that you surrender those to law enforcement within 24 hours of your release.
Sir.
So you have a bond on your Orange County case with those conditions. You don't have a bond on your VOP warrant, so that's going to be up to Brevard what they do with that, okay?
Yes, sir.
All right, good luck.
All right.
All right, sir, what's your name?
Johnson.
All right, Mr. Johnson. You're here on one count of aggravated battery with a deadly weapon and one count of providing false ID to a law enforcement officer. I'll appoint the offices of the public defender to represent you. Is he in, the face sheet says he's a violent offender of special concern. Is he entitled to a bond? He is, right? Counsel, his face sheet says he's entitled, he's a violent offender of special concern. Is he entitled to a bond today? I don't know if they're PBL, but the violent offender of special concern, he's still entitled to a bond, right? Okay. Just making sure. I'm inclined to grant a bond. I just want to make sure that we've crossed all our T's and dot all our I's, okay? Yeah, I don't see where he's on probation for any. Yeah. I just see the thing on the sheet, so that's, I just want to make sure.
Yeah, it looks like, Your Honor, just under 903.0351.
Right,
Unless he's on probation, I believe you can
right.
go ahead and.
And I don't see where he's on probation up at the top, but I did see the designation down at the bottom, so I want to make sure we're doing the right thing. Yeah, thank you. Take your time, we're good. Yeah, thanks for your patience. I know, yeah, usually we do these real quick, but sometimes we got to look at, you know, make sure we're doing it right. All right?
Your Honor, under 907.041, subsection 3B, sorry, 4. It's here. 4D as in Delta. No, back to 4C. 4C 8A. It discusses habitual violent felony offender.
I don't think it's habitual violent felony. It's the violent offender of special concern. Those are two different things, right? Yeah, I think this is like the anti-murder. If you were on probation for something else, which I'm not asking you, I don't want you to say anything. If you were on probation for something and commit or alleged to have committed the acts that you're alleged to have committed, there may be some things, but we got one thing saying you're not on probation, one thing saying you're, so we're just trying to get it right, all right? All right, okay, all right. Well, the court's satisfied that he does not qualify for violent felony offender of special concern, so you are entitled to a bond. I'm gonna set bond on count 1. I do find probable cause, although the weapon that is alleged is a little unorthodox in the definition of deadly weapon. That being the case, we're gonna set bond on that case at $1,000. Set bond in the second case, at second count, at $100. There's no victim present, so I have to order that you have no contact with the alleged victim. I understand that's your wife. I understand that you two probably reside together, but because she's not here, I have to make these, I have to do this, I have to order that you have no contact with her, and I have to order that you don't return to the residence. I can let you go back to the residence one time with the presence of law enforcement, so you contact the sheriff's office, police department, and they have to accompany you back there to get any personal belongings. Then you got to find somewhere else to stay. I've also appointed the office of the public defender to represent you. So if you want to modify those conditions, you know, we'd take some testimony, the state would hear some testimony, the court would hear some testimony from your wife, and those conditions may be able to be modified. But because she's not here, I have to impose those conditions that I just imposed. Okay, so no contact, no text messages, emails, you know, no contact through third parties whatsoever. and that you don't return to the scene other than the one-time return with the presence of law enforcement to get any personal items until further order of the court. I'm also going to order that you possess no weapons that will include knives, guns, ammunition. It will not include the wooden elephant because that's technically not a weapon. But any other weapons commonly understood to be weapons, you're not to possess those. I feel like there was something else, but I don't remember. All right, sir, so you do have a bond in this case with those conditions. I've appointed the Office of the Public Defender to represent you. Good luck. Oh, no alcohol. That's what it was. Based on the reading of this affidavit, I'm going to order that you consume no alcohol or illegal drugs as a condition of your release, okay? All right, good luck to you, sir. All right, sir, what's your name?
Eric and Macintosh.
All right, Mr. Macintosh. You're here on one count of, well, you're arrested on one count of assault domestic violence and one count of false imprisonment. The court's reviewed the arrest affidavit. I don't find probable cause as to the assault, but I do find probable cause as to battery. And I do find probable cause as to the false imprisonment. I do seek that I'm appointing the Office of the Public Defender to represent you. I do say that you qualify for pretrial release. That's a non-monetary release. There's just going to be, so you don't have to post a bond. There's going to be some special conditions, similar to the ones that you just heard me say to the man in front of you. Number one, because there's no victim here, I have to order that you have no contact with the victim. No text messages, emails, Facebook, TikTok, no third parties, no contact. Also, I have to order that you don't return to the scene, to the residence where this was alleged to have occurred. You can return one time with the presence of law enforcement to get any personal belongings, but after that, you can't go back to the residence. Also, that you possess no weapons. Guns, knives, ammunition, anything that might be considered a weapon, you're not to possess that. If you have any weapons, you're to surrender those weapons to law enforcement within 24 hours of your release. You understand? All right, good luck to you, sir. PTR. Yeah. All right, sir, what's your name?
Timothy Zimmerman.
All right, Mr. Zimmerman. You're here on one count of aggravated battery on a pregnant person, domestic violence, one count of assault, domestic violence. I've reviewed the arrest affidavit, do find probable cause as to each count. I'm appointing the Office of the Public Defender to represent you. Being no victim present, well, let's do this. I'm set bond on count one, $2,500. Count two, $500. Being no victim present, I have to order that you have no contact with the alleged victim, that you possess no weapons, and that you do not return to the scene of where this was alleged to have occurred. If you need to return to the scene to get personal belongings, you may do so, but only in the presence of law enforcement. It's a one-time return in the presence of law enforcement, only to receive personal belongings. During that visit, you're still to have no contact with the alleged victim. And no contact means no contact. I don't know if you were in here, I was explaining to the gentleman in front of you, but it's no Facebook, no Instagram, no TikTok, no emails, no text messages, no communication through third parties. No contact is no contact. It's going to be a condition of your bond. Also, I think I said no weapons. If you have any weapons, you need to surrender those to law enforcement within 24 hours of your release if you are released on this charge, okay? All right, good luck to you, sir. I did find probable cause to battery. They charged as an assault, but he actually pushed her. So we changed the charge to battery domestic violence, simple battery, and PTR, yeah. All right, sir, what's your name?
Christopher Llewellyn Burns.
All right, Mr. Burns, you're here on one count of battery was domestic in nature. Court's reviewed the arrest affidavit. That's fine, there is probable cause. I'm gonna appoint the Office of the Public Defender to represent you. 1 second. I'm gonna set bond in your case of $1,000. Conditions of release that you have no contact with the alleged victim, that you don't return to the scene where this was alleged to have occurred, that you possess no weapons. Again, I think you heard no contact means no contact, no third parties, no electronic contact, emails, text messages, social media. But because there is no victim here, I have to order that you have no contact. Also have to order that you don't return to the residence where this is alleged to have occurred. If you need to return to the residence to get any personal belongings, you may do so, but only in the presence of law enforcement. And during that visit, you're still to have no contact with the alleged victims. It's just that the purpose of that visit to only get what you need to go live somewhere else until, well, as long as this court order is in effect, okay? All right, good luck to you, sir. All right, sir, what's your name?
Franklin Cepeda.
All right, Mr. Cepeda, you are here on 1 count of battery, domestic violence. There's no victim present. I've reviewed the arrest affidavit. I do find there's probable cause. You do not qualify for the services of the public defender. You make too much money, so I can't appoint. Is that what that means? Okay. Yeah, so I can't appoint the Office of the Public Defender to represent you, but you do have the right to an attorney. If you want to hire your own attorney, you're free to do so. You do qualify for what's called pretrial release. It's non-monetary bond, a non-monetary release. So you'll be released without posting a bond, but there's going to be some special conditions. You were in here, so you heard some of those. Because there's no victim here, I have to order that you have no contact with the alleged victim. No contact means no contact. Social media, emails, text messages, no contact is no contact, not through third parties. Hey, can you relay this message? That would be contact. That'd be a violation of your release, and then you'd be picked up, and there's a chance you'd be held no bond, okay? So these, following these conditions is very important. I just want to make sure you understand that, okay? Especially since I can't appoint the Office of the Public Defender to represent you at this time. I'm just going to make sure you understand everything I'm saying, okay? No contact with the alleged victim, so that means, like I said, no contact means no contact. Also, no return to the residence where this was alleged to have occurred. You can go back to the residence one time if you need to, in the presence of law enforcement in order to get any personal belongings, and that's the only purpose for that visit. You know, if she's there or while you're there getting stuff, you still have to have no contact, okay? All right. So you can go back one time in presence of law enforcement to get personal belongings. Other than that, do not return to the scene and do not possess any weapons, firearms, ammunition, anything that could be construed as a weapon. You're not to possess that. If you have any weapons, you're to surrender those to law enforcement within 24 hours of your release, okay? That's if you have them. If you don't, then no problem, but, all right. Anything further? All right. No, hold on 1 second. I asked that question. I really didn't mean it. I don't want you to. You have the right to remain silent. Anything you say can and will be used against you. You don't currently have an attorney. Typically, it's a good idea to exercise that right. Today, we're just establishing conditions of release, which we went over. You don't have to post a bond, so you should be released as it relates to this charge today with those conditions, okay? Sure. Knowing that, if you want to ask a question, I'm happy to answer it, but just knowing that, do you have a question?
Sir,
Right.
what number would I call? Would I contact?
Your pretrial release contact, it's all going to be in your paperwork.
Oh, for the sheriff.
Oh, whatever local agency, wherever you're at, it can be Orange County Sheriff's Office, it can be, depending on where you live, Winter Garden Police Department, Amoy Police Department. As long as it's a duly authorized law enforcement agency, they just need to be there. So, you know how to use the internet, I'm assuming.
Right, yeah.
So wherever you live, just the Sheriff's Office is probably your best bet. Just contact the Orange County Sheriff's Office, let them know you've got a one-time return. Trust me, they've done it before, okay? They'll know what to do.
Did I meet them there, or they'll call?
They'll tell you what to do. You just want to call them first. Don't go there and then call them first, all right?
Sure.
All right, good luck to you. All right, sir, what's your name?
Clayton.
All right, Mr. Clayton, you're here on 1 count of battery, domestic violence. I don't see a victim here. I've reviewed the arrest affidavit. I do find there is probable cause. I'm going to appoint the Office of the Public Defender to represent you. You also qualify for what's called pretrial release, which is non-monetary release, but there's going to be conditions similar to the ones we just said to the gentleman in front of you. Because there's no victim here, I have to order that you have no contact, okay? So no contact means no contact, not through third parties, social media, anything, okay? I have to order that you do not return to the residence. I can allow you to return to the residence one time, and I will allow you to return to the residence one time in the presence of law enforcement to retrieve any personal belongings. Other than that, you cannot return to the residence. Also order that you possess no weapons, firearms, ammunition. You understand?
Yes, sir.
All right, good luck to you.
Was PD appointed, Judge?
What's that? PD was appointed, correct.
Your Honor, Dangali, Kamari is mental health.
All right, I'll appoint the office of the public defender to represent Mr. Dangali.
And we'll waive his appearance, Your Honor.
Review the affidavit, do find there's probable cause. If he does qualify for pretrial release, we'll order him on pretrial release, special conditions, no contact, no return, no weapons. Other than that, if he does not qualify, we'll set bond at $500 with the same conditions. And no contact. Was this a house? I think it was. Yeah, it was. Yeah, he can return one time in the presence of law enforcement to get personal belongings. All right, ma'am, what's your name?
Alicia Jones.
All right, Ms. Jones, you're here one count of battery domestic violence. I've reviewed the arrest affidavit. I do find there is probable cause. I'll appoint the office of the public defender to represent you. You do qualify for what's called pretrial release. That's a non-monetary release, so you'll be released as discharged today. The conditions of your release, because there's no victim here, I have to order that you have no contact with the alleged victim. That's no text messages, emails, no contact through third parties, any social media, anything like that. That you do not return to the residence where this was alleged to have occurred. I will allow you to return one time in the presence of law enforcement to get any personal belongings. Also order that you possess no weapons or ammunition.
Judge, if I may, as to the no return, it's her apartment. Her father and children also live there, and she's represented that the alleged victim does not live there.
Okay. Under those representations, you can return to the apartment and you can live there. At any time, however, the alleged victim begins to live there. I don't know how else to say it, but if he starts living there, you have to leave, okay? Because you're the one that's charged with the criminal. If he doesn't live there, it's no problem. So it doesn't sound like it's going to be a problem, but just in case he comes back, until further order of the court, these orders can always be modified, okay? You have an attorney to represent you, so if facts change, circumstances change, these can always be modified. The no contact order is going to remain in effect, but you can return to the residence, be it that it's your residence. You can return there and you can live there, but you're still to have no contact with the alleged victim, okay? Maintain separate residence. Let's do that. You're just to maintain separate residence. We're going to say it that way. So you guys can't live together. All right? Thank you. That's what I was trying to say. That's an easy way to say it.
Your Honor, Morales, Ortiz, Enoch, Abraham is behavior.
All right, I'll appoint the office of the public defender to represent Mr. Morales Ortiz.
We'll waive his appearance, Your Honor.
All right, I've reviewed the arrest affidavit. I do find there's probable cause.
Your Honor, could we see if he qualifies for some form of pretrial release. I don't know if he was interviewed.
Now, we can order him screened for pretrial release if he qualifies. He can be released as pretrial release with the conditions, no contact, no return, and no weapons. If he does not qualify, we'll set bond at $250, same conditions.
Thank you, Your Honor.
All right, sir, what's your name?
Sellers, sir. Michael Sellers.
All right, Mr. Sellers, give me one moment. All right, you're here on one count of battery, domestic violence. I reviewed the arrest affidavit. I do find there is probable cause. Ma'am, what is your name?
Rebecca Sellers.
Speaking to the microphone, I couldn't hear you.
Rebecca Sellers.
All right, and are you the alleged victim in this case?
Yes,
All right, what's your relationship to Mr. Sellers?
I'm his wife.
Okay, 1 second. All right, so the purpose for today's hearing is to establish conditions of release. So thank you for coming here because your input is very important in establishing those conditions. If you weren't here, you saw what happened to the people in front of you. We have to order no contact. If you want no contact, we can still do that. We can also order that you have no hostile contact with you, which that just means no arguing, no fighting, no raising your voice. Anything that can be considered hostile contact would be a violation of the conditions of release. We can order that you guys maintain separate residences. So what would you like to see happen here today?
I would like him to stay away from us. No contact
All right, are you afraid of him?
sometimes.
You two living together?
Yes,
Okay. All right, sir, I'm appointing the Office of the Public Defender's Office to represent you.
excuse me?
Based on the testimony that was here today, I'm gonna set bond.
He
Based on
qualifies.
the allegation, I'm gonna set bond at $500.
I think he qualifies for PTR.
Oh, he does. Okay, sorry. You do qualify for what's called pretrial release. That's a non-monetary release. So you don't have to post a bond, but there's conditions. It's a supervised release, okay? Those special conditions, based on testimony here today, is that you have no contact with your wife, or the alleged victim in this case.
Excuse me?
I know in certain situations, how long have you guys been married? I'm gonna ask your wife. How long have you guys been married?
10 years,
Okay.
but there's something I'd like to ask you.
Okay,
I have a stepson who's intellectually disabled and autistic, and sometimes Michael will antagonize him.
it's Michael's child?
Yes.
Okay.
So I'd like it if he could not pick him up from school. He tends to antagonize him on purpose and causes a lot of distress.
I
And there's
understand.
an appointment at Nemours Hospital on the 12th of September, and Michael needs to be there because it's an MRI and the child has to be sedated.
All right. What you're asking for there may be a separate, you may have to file a separate petition in a family court or something like that. We're here on the battery domestic violence. The conditions of release are going to be related to that. I understand the concern, I understand your testimony, be it that it is your child. I'm not going to order that you have no contact with your child, but I am going to order that he have no contact with you, okay? I'm also going to order that you maintain separate residences and that you do not return to the residence where this was alleged to have occurred. Will allow you to return one time in the presence of law enforcement to get any personal belongings, then you got to find somewhere else to stay, okay? Until further order of the court. During that one-time visit, the no contact order is still in effect. So if she's there, you just can't have contact with her. The law enforcement should take care of all that, but just I'm making you aware, okay? The purpose of that visit is only to get anything you need to go stay somewhere else. I'm also going to order that you possess no weapons. and that anything that be construed as a weapons and/or ammunition, if you have any weapons and/or ammunition, that you surrender those to law enforcement within 24 hours of your release. The only other thing I would say, it's just what I told the gentleman before you, the one-time return with law enforcement, call law enforcement first. Don't go there and then call law enforcement. Make sure you call the sheriff's office, whichever duly authorized law enforcement agency you choose to call them first and go there with them. It happens sometimes where people show up there and then call the sheriff's office. That's not how it works, okay? So call and then follow any instructions that they give you. All right, good luck to you, sir.
Judge, I just have one question. Regarding the stepson, I don't know if they share custody of him or how that works, because it sounds like there may need to be communication regarding the stepson, at least for this appointment.
All right, so as it relates to this appointment, it sounds like you're the one that has to be there because you're the parent.
The biological, yeah.
You're the biological father. If that's the case,
Your Honor, is there a third-party adult?
yeah, that's what we're gonna do.
No, I understand. Do you guys share custody?
Thank you, State. The two of you may communicate through a responsible third party only as it relates to the custody of the special needs child, okay?
Does that make sense?
You two can't communicate to each other. Is there somebody that we can, someone we can agree to that'll be that third person today? Do you have any preference of who that third person might be?
We have my dad and we have his dad.
All right, we'll do it this way.
But are you talking about the Nemours appointment?
Yeah,
Okay.
because it may be a situation, if he's the one that has to be there, you're not there. It may have to, if I'm ordering you guys to have no contact, and there's a child involved that has an appointment coming up, and he's the one that has to sign all the paperwork, he needs to be there, where I can't have you guys there at the same time, okay? So, it can be either your dad or your dad will be the third parties that can be used to coordinate custody of but that's it. No other communication, no other, hey, can I come home? No, you stay away. No calling him names through the third party. No calling her names through the third party. The third parties can only be used for the purpose of communicating custody and transportation of the child, okay?
So can he go to the hospital and do all the paperwork, sign it, and then he could leave and I could be there for Zachary?
Whatever arrangement you guys work out, as long as you two aren't having contact with each other. And I can't require this in a court order because it's subject to, it's too broad of interpretation or to interpret, but I'm gonna ask both of you, I know family stuff gets a little heated sometimes, to be reasonable as it relates to the child, okay? It's kind of sticky. It's not a situation that's easily figured out. It requires both sides of the coin to give and take a little. So I'm just gonna ask you, while we've got everyone here, you have no contact with each other directly. You may only contact each other through third parties as it relates to the minor child. And the court would just request that those communications and those arrangements regarding the minor child, or not the minor child, the child, that the parties conduct themselves reasonably and with the best interest of the child, kind of leading the way there, okay?
Yes.
I I did previously appoint the Office of the Public Defender to represent you. You are going to be released as it relates to this charge today. Upon your release, if you have any questions or want the order modified, you can contact your attorney, okay? All right. So once you get out, if you need the order modified, there's motions that can be filed. You're going to be released. Just make sure you have contact with your attorney. But other than that, you'll be released as a discharge under those conditions that we talked about, okay? All right, good luck to you. And thank you, ma'am.
Too.
All right, sir, what's your name?
You have Shinoda.
All right, Mr. Shinoda, you're here on one count of battery, touch, or strike. It was domestic in nature. See, no victim is present. I will appoint the Office of the Public Defender to represent you. I see that you do qualify for pretrial release. That's a non-monetary release, so you'll be released as it relates to this charge today. There being no victim present, though, there's going to be the following conditions as the conditions of your release. Which, if you violate any of these conditions, you can be picked up on a violation of your release or of your pretrial release and potentially be held no bond. You understand? All right. So the conditions are going to be that you have no contact with the alleged victim. No contact with third parties, no contact directly through text messages, emails, Facebook, any social media, anything. Do not return to the residence where this is alleged to have occurred. You can return one time. You can return one time with the presence of law enforcement to get any personal belongings. In order that you and the alleged victim, and other than that, maintain separate residences until further order of the court, and also that you possess no weapons or ammunition. Okay?
Your Honor, Your Honor, can I speak?
Well, here's the thing. I've appointed the Office of the Public Defender to represent you, so you have an attorney. Today we are just establishing conditions of your release. Anything you say can and will be used against you. You have the right to remain silent. So anything you want to ask, you might want to run it by your attorney first. Oh, thank you very much. Thank you.
Not right this minute, but.
All right, sir, I've appointed the Office of Public Defender to represent you. You are going to be released as it relates to this charge today. Any questions that you have concerning pretrial release, if it's not answered in your paperwork, you can call the Public Defender's office once you're released. We just got a room full of people back there we're trying to get through. So any questions, you have the right to an attorney. I've appointed them to represent you. Any questions that you have, you can call them and they'll answer those for you, okay?
Thank you, Your Honor.
All right, thank you.
You're welcome.
All right, thank you, good luck. All right, sir, what's your name?
Tyrell Torres.
All right, Mr. Torres, you're here on one count of battery, domestic violence. There is no victim present. I've reviewed the arrest affidavit. I do see that, I do find that there's probable cause. I also see you qualify for what's called pretrial release. which is a non-monetary release, so you don't have to post the bond, but there's a supervised release, so there's going to be some conditions, okay? I will appoint the Office of the Public Defender to represent you. Your conditions of your release are going to be that you have no contact with the alleged victim because she's not here. I have to order that you have no contact with her. That can always be modified later if she wants to have contact, but that's going to be today. The court's order today is that you have no contact. Also, that you do not return to the residence where this was alleged to have occurred. You can return one time if you have personal belongings there. You can return one time under the accompaniment of law enforcement. Get any personal belongings, then you gotta live somewhere else. Okay. Also, order that you consume no alcohol as a condition of your release, and that you possess no weapons or ammunition. All right. All right. But as it relates to this charge, you should be released as it relates to this charge today with those conditions. Okay.
Judge, he has a question regarding pretrial release. He's a CDL driver. Is pretrial release going to be an issue if he needs to go out of state or anything like that?
They're here. I mean, out of state may be an issue. We'll note that the court has no objection to you traveling out of state for work, if that helps. We'll put that, the court has no objection to him traveling out of state for work. He's a CDL driver.
Yeah, my job goes to Georgia, Tennessee.
Yeah. It'll be up to pretrial release, but the court has no objection. But I mean, pretrial release is sitting right. Is that usually is that usually okay? If he travel? Yeah, they'll do it. Okay. Well, we did the best we could, so hopefully that's not a problem. All right? If it is a problem, you have an attorney appointed to represent you, contact them and let them know, and we'll see if we can't get it, if you can't get it figured out, okay? All right, ma'am, what's your name?
Yasmin Barksdale.
All right, Ms. Barksdale. You're here on one count of burglary of a structure with assault or battery therein. Burglary of a conveyance is, with an assault is the PBL, but burglary of a structure is that's not a PBL, correct?
No, it's not, Your Honor.
All right. Court's reviewed the affidavit. I do find there's probable cause. I'll appoint the Office of the Public Defender to represent you. I'm going to stay the bond on count 1 at $5,000, stay the bond on count 2 at $150, and stay the bond on count 3 at $100. Also order that you do not return to the business where this was alleged to have taken place, okay?
Can I take down my mask so I can breathe?
No.
I can't?
No. But we're done, so you're going to step outside. That's
No, I have something to say.
All right, I've appointed the Office of the Public Defender to represent you. You have the right to remain silent. Everything you say can and will be used against you. Usually when you have an attorney and you, hold on, I'm not done. I have something to say too. Hold on. Usually when you have an attorney, it's a good idea to exercise your right to remain silent. The purpose of today's hearing is only to set the conditions of release. The job of the judge here today is to take every word that's written in this arrest affidavit as true, whether you believe it's true or not. To talk about the facts of your case here today usually cannot help you, and usually always comes back to bite you.
Well, I have a concern.
I understand. Understanding that you have those rights, and that by waiving those rights, what you say will probably be used against you, you can ask me whatever you want.
I'm not supposed to talk to you?
You can ask your attorney. Yeah, that's probably a good idea too. Let me use a little anecdote while you're standing there too. When I used to be a defense attorney, I represented a guy at the jail who was charged with robbery while wearing a mask. He was very And we gave him the same speech I just gave you, and the judge who was sitting in this chair said, "Sir, you're charged with 1 count of robbery while wearing a mask." To which he responds, "I wasn't wearing a mask when I went in there." So any defense that he maybe wasn't there, it wasn't him. He's now copped to a robbery, and he said, "I had a sock on my head. It wasn't a mask." So it serves no purpose to talk about the facts of your case here today, other than to put you at the scene, maybe eliminate some other defenses you might have down the road. Today's not your trial. I'm only telling you this to help you out. I'm being honest. All right. I used to be a defense attorney. So I'm just telling you that you have bonds on this. You can bond out. I'm ordering you just don't go back there. Okay.
My family should already be paying my bond. And what do I do now?
All right. Good luck to you, ma'am. It's a true story, by the way.
I believe it.
Judge, I have a probable cause challenge as to this case.
All right. Sir, what is your name? All right, Mr. Barnett, we're here. You were charged with 1 count of burglary of a structure, 1 count of petty theft. I'll appoint the Office of the Public Defender to represent you in this case. Your attorney has indicated she has an argument to make as to probable cause. Counsel, you may proceed.
Yes, Your Honor. As to the count of petty theft, I would just note in the affidavit, there are a couple of things. It's not indicated exactly what was stolen. It says that he was seen, Sergeant Rutkowski found him carrying items typically found in construction sites, duct tape, and cold Coca-Cola cans. They are believed to have been taken from a cooler inside. However, the owner of the property was contacted. He said he was not able to respond to the scene and could not provide an exact value for the items taken due to him being out of town. So my argument would be, Your Honor, this is vague as to what was taken. We don't actually know if the items taken belong to that property or not. And for those reasons, I don't think that there's probable cause that a petty theft was committed.
State, do you have any response?
This,
The court's going to take it a step further. We don't know that if he didn't have those things prior to entering.
Yes,
So-
Your Honor.
All right,
based
All right.
on the way that it's written, yeah.
right. Okay,
Argument.
so we'll find no probable cause as it relates to the petty theft, RORU as to that charge. With regards to the burglary of a structure, court does find there is probable cause on that offense. Based on, let me look at something. I'm also going to ROR him on the burglary of a structure with the condition that you do not return to this scene. And also that you don't return to any construction site unless you are there to perform a job. Okay? That's residential, commercial, any construction site. You are not to be on any construction site unless you are authorized by the superintendent or someone with the authority to allow you to be there, and that you're there performing a job. Okay? All right. Good luck to you, sir.
Your Honor, Bruner, Torres, Joshua, refused.
All right, I will appoint the Office of the Public Defender to represent Mr. Bruner. I reviewed the arrest affidavit. Well, you waive his appearance?
Yes, Your Honor.
All right. Reviewed the arrest affidavit. Do find there's probable cause. I'm going to stay the bonds on count 1 and 2.
Butler Robin, behavior.
All right, Ms. Butler, I'll appoint the Office of the Public Defender to represent Ms. Butler.
We'll waive her appearance, and I do have probable cause challenges on this case as well, Judge.
Is it just on the resisting?
It was on the resisting and also on the possession of cannabis with intent to sell. Specifically, I don't see kind of the intent to sell. I know that there's 106 grams, however, there aren't any smaller baggies.
Right.
It's in 2 large bags. There's no denomination of money that she had.
At some point, is there a weight that puts it in the intent, or, I know with some
I'm not
controlled
positive.
substances, there's a weight that just moves it into, well, that may be trafficking. She's not charged with trafficking.
No, Your Honor.
So,
A state would just argue that it's more than the typical amount that one person would own for personal consumption.
yeah. All right, I think the possession over 20 grams kind of encompasses that. I think that's a little redundant with the possession of cannabis with intent to sell and deliver, and that there's no probable cause of the intent to sell. Maybe a lot of weed, but some people have a lot of weed. And that's encompassed in the possession of cannabis over 20 grams. So probable causes to count 2, count 3. I went back and forth on count 4. Do you have arguments as to count 4?
Yes, Your Honor. I think the only allegation that would maybe fit under resisting is that she gave a different name. However, then that should be charged as false ID to law enforcement, and I don't think that falls under resisting, obstructing, or opposing law enforcement.
I had the same thought you did, counsel. I think, given, a broad reading of it, may fall under obstruct. So I'm going to find probable cause on that one, but I understand the argument.
Sure.
So I'll find probable cause on count 2, set bond. Because of the amount, the court will consider that. We'll set bond at $2,500 on count 2. RR is to count 1. Set bonds on counts 3 and 4 at $100.
And Your Honor, I believe this defendant has a couple other cases.
Mr. Butler?
Yes, Your Honor.
Yes.
Oh, well, let me.
There's a CT and an MM.
Oh, yeah, 3 cases. All the other ones are, all right, so failure to appear on driving while license suspended, that came in on a warrant. We'll appoint the public defender on that one, stay the bond at 500. And failure to appear for a different charge, we'll stay that bond at 1,000. And appoint the public defender in that case as well. All right, sir, what's your name?
Raul Campbell Byrd.
All right, sir, you have 2 cases. Well, one of them is a failure to appear on account of burglary and petty theft. The bonds in that case are $5,000 and $1,000 respectively. The court will stay the bonds in that case. You're also here on a new law violation, trespass on property after warning. Court's reviewed the arrest affidavit. Does find there is probable cause. I'll appoint the public defender to represent you on that case as well. You're also out on bond on a charge of driving while license suspended with knowledge. Does the state have a position as to the case he was out on bond on?
State would have no objection to taking no action.
All right. All right, sir, the court was inclined to revoke your bond. You're out on bond, you got to stay out of trouble, okay? And when you're out on bond on a separate case, you start being in places you're not supposed to be, you got to live a little cleaner when you're out on bond, because when you come back here, the court would be within its right to revoke your bond and hold you no bond on that case you're out on bond on. Because the state has no objection to taking no action, the court's going to take no action. But let this be, a warning shot, all right?
Sir.
Yeah, you get picked up again for, something as little as a trespass. You're not entitled to a bond anymore. So stay out of law enforcement's purview, okay? All right, good luck to you, sir. 500, sorry.
Did you do no return?
Yeah, we'll stay, and no return. 500.
Your Honor, Davis James is outside medical.
All right, Mr. James, I'll appoint the Office of the Public Defender to represent Mr. James, who is charged with grand theft, third degree, and aggravated battery with a firearm, although not the typical way of firearm.
And Your Honor, I have a probable cause challenge as to the grand theft.
All right, let's hear it.
Yes, Your Honor. For the grand theft, I actually don't see anywhere that anything was taken. I know that there was a bit of a alleged scuffle over the weapon. However, it says that Daniel stated he was able to retrieve the weapon away from the suspect. And then a different victim listed, Charles Mullins, said he didn't give anyone permission to mess with or take anything from his truck. He isn't alleged to have taken the truck, so I'm unsure of as to what he actually took. And there's no value as to what he took either.
State.
I'm sorry if I could have just one moment.
Yeah, take your time. I'm reading it too. I see why he's in medical. The parties agree he is entitled to a bond on the aggravated battery with a firearm?
Yes, Your Honor, it's a F2.
Okay. I've reviewed the affidavit. I understand defense's argument, and I don't see where they said he took anything other than the firearm itself. And while that might constitute some other offense, I don't think that was the offense contemplated by the grand theft allegation. So the court's going to ROR on that case, on that count. Count 2, however, I am going to find probable cause. I'm going to set bond on that case. $10,000, no contact, no return, and no weapons.
Your Honor, Garcia Christopher, behavior.
I will appoint the Office of the Public Defender to represent Mr. Garcia.
We'll waive his appearance.
All right, I've reviewed the arrest affidavit. Do find there's probable cause. Court's going to stay the bond at $1,000. Garcia. Here's another. I just hadn't been handing those to you. Sorry. Yeah. All right, sir. What's your name?
Yes, sir. Dante Hayes.
All right, Mr. Hayes. You've been arrested and you have 6 counts. First count, trafficking in cocaine less than 28, or greater than 28, less than 200 grams, attempted sale or delivery of cannabis, trafficking in MDMA, fleeing and attempting to elude, leaving the scene of a crash with property damage, and no valid driver's license. I'll appoint the Office of the Public Defender to represent you. Courts reviewed the arrest affidavit. Has found probable cause as to each count. Court's going to stay the bond on count 1 at $50,000. Count 2, bond will be $100. Count 3, $5,000. Count 4, $1,000. Count 5 and 6 will each be $100. All right, sir. Good luck to you.
Judge, I think he also had,
Oh, did he have another?
the contempt case. Oh, it went away. Okay. I just had that it was on there. Okay. Sorry, Bob, it's okay.
Count 1 was 50. Count 2, what did I say for count 2, 100? Yeah, and count 3 was 5,000. Then 4, you got 4, 5, and 6. Okay, all right. Yep. All right, sir, what's your name?
Yeah, Jackson, sir.
All right, Mr. Jackson, you are here. 1 count of possession of cocaine, 1 count of possession of MDMA. You were out on bond on a similar offense. Court's going to appoint the Office of the Public Defender to represent you in this case. It's going to stay the bond on, the court's reviewed the arrest affidavit, finds probable cause as to counts 1 and 2. Set bond at $1,000 on count 1, $100 on count 2. In case you're out on bond, 2022 CF 6694AO. Court's going to revoke that bond and set bond at none in that case. If the Office of the Public Defender hasn't been appointed in that case, I'll appoint them to represent you in that case as well, so they can file any motions that you need filed, okay? All right, good luck to you, sir. Sorry. Sir, you have the Office of the Public Defender appointed to represent you. You're being held no bond because you were out on bond and picked up a new offense, so we revoked the bond in that case. The Office of the Public Defenders have been appointed to represent you, so any motions that you need filed, anything, any questions you may have, you need to run those through your attorney, okay? All right, the only thing we're doing today, we've already done, so you can have a step outside. All right? All right, sir, what's your name? All right. Did we lose Tyrell Jackson?
I don't have him.
All right, 2022, or 22020-804. How'd he bond? Huh? How'd he bond? I have him as a no bond, failure to appear warrant. Tyrell Jackson? Yeah. What's that? Oh, he went to court? Okay, all right. So he bonded. All right, well, that makes me feel better. I was a little worried there for a minute. All right, sir, what's your name?
Marcus Lawrence.
All right, Mr. Lawrence, you are here on 1 count of driving while license suspended or revoked as a habitual offender, and another count of driving while license suspended. I'll appoint the Office of the Public Defender to represent you. Were these two separate tickets? Hold on, no, I'm not asking you. I've appointed the Office of the Public Defender. Just not saying that to be rude, just anything you say can and will be used against you. I don't want you to say anything that may bite you. You know, if your defense is you're not driving, I don't want you to say, yeah, it's two tickets, and now you've admitted to driving both times. So I'm just gonna ask your attorney. I appointed your attorney to represent you so she can, you wanna say something, say it through her.
So Judge, I see that there were several citations written. However, I think it's all the same event. He was only stopped one time. And so my argument would be that only one should apply.
All right, well, I've reviewed the affidavit. I find probable cause as to, it's probably easier to find probable cause as to count two. So I'm gonna set bond on count two at $2,500. Bond on count one will be ROR. You're also out on bond for driving while license suspended. We're gonna revoke the bond in that case and set it at none. You got it, yeah, I'm, just understand that's what we're doing here today. You gotta quit driving. Yeah, point the PD on both. All right, I've appointed the Public Defender's Office. They can file any appropriate motions that you may need, so just stay in contact with them, but we're done for today, okay? That's all that's happening today, so good luck.
And Judge, that's on both cases, right?
That you got appointed?
Yeah, because we're not appointed on the other case.
Yeah, appointed on both.
Thank you.
Your Honor, Nelson Robert is mental health.
All right, well, we will appoint the Office of the Public Defender to
We'll waive, Your
represent
Honor.
Mr. Nelson. Court does find probable cause.
Your Honor, is it possible for him to get interviewed for pretrial release?
I see he doesn't have a lot of, or any history really, so we'll have him interviewed for pretrial release. If he qualifies, he shall be so released. If not, we'll stay the bonds. 1,000 and 500. 1,000 on one, 500 on two.
Just confirm on the last one, you said you didn't have probable cause on one of the counts.
On count. Yeah. Oh, no. Yeah, count two. Yeah. All right, sir, what's your name?
Robles.
All right, Mr. Robles, you're here on one count of carrying a concealed firearm. I've reviewed the arrest affidavit. I do find there's probable cause. I will appoint the Office of the Public Defender to represent you. I'll set bond, I'm gonna stay the bond at $1,000 with the condition that you do not possess any weapons or ammunition. If you have any weapons or ammunition, you need to surrender those to law enforcement within 24 hours of your release, okay?
Yes, sir.
All right, good luck to you. Yep. Just don't possess any illegal drugs. Yeah,
Robert Nelson, was that mental health PTR or just normal?
regular PTR. All right, sir, what's your name?
Nicholas Sands.
All right, Mr. Sands, you're here with aggravated assault with a deadly weapon. I've reviewed the arrest affidavit. I do find there is probable cause. I'll appoint the Office of the Public Defender to represent you. I do see no victim here, so I'm gonna stay the bond at $2,500. Because there's no victim here, I have to order that you have no contact with any alleged victim. I have to order you do not return to the residence where this was alleged to have occurred. If you need to return one time to get any personal belongings.
In this case, I am the victim.
I understand. Today's not your trial. I have to take every word that's written in here as true for today's purposes only, not saying it is true. But today we're just making a probable cause determination. I've reviewed it. I determined there is probable cause. I've appointed the public defender's office to represent you, so you have an attorney. I'm giving you a bond on this case, but the bond's gonna have some conditions just based on the allegations. So all these are allegations. The
Yes.
court has to impose some conditions based on the allegations, okay? The allegations are warrant, and the fact that there's no alleged victim here, and I said alleged victim, that's, that's where we're at in your proceedings. That you have no contact with any of the alleged victims, okay? And that you don't return to the residence where this was alleged to have occurred. If you do need to return to get any personal items or anything like that, you can do so, but you have to do so with the presence of law enforcement, and call law enforcement first. Don't show up there first and then call the cops and say, I'm here to get my stuff. Call the cops first, then go to get your stuff if that's something you need to do. Other than that, I'm gonna order that you possess no weapons or ammunition, but you have a bond with those conditions, okay? And that's what we're doing today, so good luck to you, sir.
Your Honor, Sergeant Noel.
Mhm. And we already did,
Yeah, we addressed him. He was a move up.
Awesome.
No worries.
yeah,
Fatra, Archit bonded.
all right. How did he bond? Oh, yeah. All right, man, what's your name?
Tammy Gill speaking.
All right, how do you say your last name?
Speakman.
All right, Ms. Speakman, you're here on 2 counts. 1 count of possession of methamphetamine, 1 count of possession of drug paraphernalia. I'm going to appoint the Office of the Public Defender's Office to represent you. I've reviewed the arrest affidavit. Do find there's probable cause. The court's inclined to stay the bonds on both counts, $1,500 on count 1 and $100 on count 2, okay? All right, good luck to you.
Thank you.
All right, sir, what's your name?
Michael Alvarado, sir.
What happened to Ricky Williams? Do you have Ricky Williams? All right. 220. All right. 220-20798. Yeah. All right. Thank you. All right, sir, your name again?
Michael Alvarado.
All right, sir, you're here on 1 count of DUI with property damage.
What, DUI?
No, that's not him. You're
That's not me.
Oh, I'm sorry. Yeah, Griffin. I will. Hold on 1 second. 220-20815. Yep. All right. All right, sir, you, Michael Alvarado, how do you say your last name?
It's Alvarado.
Okay,
They messed up on the ID, by the way. It's not Alvarado. It's
so
Alvarado.
the second V should be a D? Alvarado,
Yeah, Alvarado.
all right. All right, sir, you're here, you were arrested, you have 3 counts, 1 simple assault, intent, threat to do violence. Count 2, trespass, fail to leave property. Count 3, resisting an officer without violence.
Yes.
Yeah, I'm just, give me 1 second. I'm appointing the Office of the Public Defender's Office to represent you. I've reviewed the arrest affidavit. I do find there's probable cause. So,
I think he qualifies.
what's that?
PTR, Your Honor.
Yeah, thank you. You do qualify for what's called pretrial release. It's a non-monetary release, so you're going to be released as discharged today. It's supervised release, so it's kind of like probation there, but you just kind of have to check in and stay out of trouble as a condition of your release.
Oh, yes, sir.
And I'm also going to order that you do not return to the Miller's Ale House in Winter Garden, okay?
Oh, I definitely will not go back over
No,
there, sir.
that's all right.
You have my word on that.
Right. So, well, now it's a court order, so don't go back there. If you go back there, they can call the police and
Yes, sir.
there's a chance you can be held no bond, okay?
Yes, sir.
All right, good luck to you, sir.
What does PTR mean? No bond, no. Thank you, thank you.
Yep, good luck.
And Judge, Ms. Baker is going to be a plea.
All righty. To both, she was out on bond, is it to both cases or just to?
Just to the one before us, Your Honor, I don't have an offer on the other one, unless,
Your Honor, the state would ask for no action taken on the out-on-bond case.
Perfect. I was intending on doing that anyway, but now you've given me the blessing.
so,
Thank you.
right? Credit time served, you'll get out today. Okay.
Makes it easier. Well, thank you. All right, ma'am, what is your name?
Latricia Baker.
All right, can you please raise your right hand? Swear to tell the truth, the whole truth, and nothing but the truth? All right. I was handed a plea form by your attorney. Well, let me ask your attorney this. What's the agreed upon resolution?
AG court cost credit time served.
I see it right there. All right, I was handed a plea form by your attorney. Did you have a chance to go over this plea form with your attorney? Yes. And I'm saying your attorney, I have not appointed the office of the public defender to represent you. It's going to save you about $50. She's speaking to you as a friend of the court, okay? Yes. The attorney standing next to you, did she, you understand that by resolving your case here today, there's not going to be a trial and that you're waiving the rights that are listed on this plea form? Yes. All right. You don't have to keep putting your hand up. Yeah.
You're okay.
But I appreciate you doing that. You're under the influence of any drugs, alcohol, medications affecting your ability to understand what's happening here today?
No, sir.
Anyone threaten you or coerce you to enter this plea?
No, sir.
You understand that if you were on probation for any other offense, a plea to this offense might be used to violate that probation?
Yes, sir.
You understand that if you're not a U.S. citizen, a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
And do you understand that if you are not a U.S. citizen, a plea to this offense could subject you to deportation?
Yes, sir.
Not could, it would. You understand that?
Yes, sir.
All right. All right. Well, the court will accept the no contest plea, adjudicate you guilty, assess court costs of, well, assess court costs. I'll give you 1 year to pay the court costs or to be on a payment plan making regular payments, okay? Yes, sir. All right, sends you to how many days this year? Since you 1 day in the Orange County Jail with credit for the 1 day that you've already served. What, 9/4? Today, right?
Your Honor, it looks like the date and time of arrest was 9/3,
When did I just look at?
unless it's a typo on the,
9/4? Oh, no. You go by a different name?
No, Latricia Baker.
It's my mistake. Mine got, she got, I messed up. She was attached to the Brittany, I think the young lady sitting right behind you, so sorry. Yeah, 9/3. So we'll send you to 2 days in the Orange County Jail with credit for 2 days time served, okay? You'll be released as it relates to this charge today. You're also out on bond on a separate offense. Court's gonna take no action on that case, okay? All right.
Sir.
You're welcome. Good luck to you. But just know, like I told someone earlier, when you're out on bond, you got to be extra careful because the state was gracious enough today to request the court take no action. When you come back with new law violations, when you're out on bond, you're not entitled to a bond anymore. Depending on who the judge is sitting up here next time, hopefully there's not a next time, but there are a lot of judges in this circuit that if you're sitting up here and you come in here with a new law violation when you're out on bond, it's, wham, bam, thank you, ma'am. You sit in jail, no bond until your other case gets resolved, okay? So just consider that a warning shot, all right? You're welcome. Good luck. Oh, there's the. All right, man, what's your name?
Brittany Danitz.
All right, Miss Danitz, you were arrested today on one count of trespass on property after warning.
She's going to plea, Your Honor.
Okay. All right, ma'am, I was handed a plea form. Do you have a chance to go over this plea form with the attorney standing next to you?
Yes, sir.
All right, you understand that by resolving your case here today, there's not going to be a trial and that you're waiving the rights associated with going to trial?
Yes, sir.
All right. You under the influence of any drugs, alcohol, medication affecting your ability to understand what's happening here today? All right, anyone threaten you or coerce you to enter this plea?
No, sir.
Do you understand if you're not a U.S. citizen, a plea of this offense will subject you to deportation?
Yes, sir.
And do you understand that if you are on probation for a separate offense, a plea to this offense might be used to violate that probation? All right. Do you understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
All right, well, accept the no contest plea, adjudicate you guilty, assess court costs. I'll give you 1 year to pay the court costs. You were arrested on 9/4, so I'll sentence you to 1 day in the Orange County Jail with credit for 1 day time served, so you'll be released as it relates to this charge today. As a condition of your sentence too, you're not to return to Southern Nights. For whatever reason, they don't want you there, you can't go back there, okay? It's become apparent that you are not welcome at Southern Nights, so just don't go back there, okay?
Yes, sir. Thank
All right.
Your Honor, Farrell Kevin, bonded.
All right, Kevin Farrell. Trespass on property after warning. Oh, he bonded. Good luck to him. Ma'am, what's your name? All right, Miss Medina. You're here on 1 count of possession of drug paraphernalia. The court's reviewed the arrest affidavit, does find there's probable cause. I'll appoint the Office of the Public Defender to represent you.
Your Honor, may I be heard as to release conditions?
Yes.
We would ask for ROR in this case. This is a case that may be eligible for pretrial diversion, and so we would ask for ROR.
All right, let me review it again. I reviewed it for probable cause. Let me see if ROR is appropriate. Ma'am, I'm not asking you, I'm asking the attorney. Was Mr. Jackson, was he the one that was out on bond? What did we do with Mr. Jackson? I know he's a co-defendant in this
Let me
case.
see. Can't recall, he must have been a felony case. Was that Del Jackson, Your Honor?
Correct.
Yes, he had his bond stayed, that was possession of cocaine and possession of MDMA. They're at $1,000 and $150.
Is he not out on bond on another one?
He was out on bond on another case, Your Honor.
We
It was
revoked that
revoked,
bond.
yes.
Okay. All right, we are gonna, the court is inclined to, the court's gonna ROR you on this. So you're gonna be released as this charge today. The court's gonna require that you possess no controlled substances without a valid prescription. If you get caught with any of that, you're gonna come back on a violation of conditions of release. And I'm assuming you know Mr. Jackson, I'm not asking, but that's what happened to him, and now he's sitting in here with no bond, okay? So don't let that happen to you. I'll appoint the Office of the Public Defender to represent you, but those will be the conditions of your release, okay? Sir, what's your name?
Jeremy Oben.
All right, Mr. Oben, you're here on 1 count of possession of drug paraphernalia. Reviewed the arrest affidavit, do find there's probable cause. I'll appoint the Office of the Public Defender's Office to represent you.
And we would also ask for ROR on this case, Your Honor. It should be eligible for diversion.
Diversion?
Yes, Your Honor. There's a pretrial diversion program that the state generally offers with paraphernalia charges.
Okay. Even with his history?
That's my understanding, Your Honor.
Okay, I'm just curious.
Yeah, the
I know
state,
things have changed a lot, so.
the state could correct me on that, but I believe so.
I mean, his history, I mean, you see it. Would he be eligible for diversion with that history? It's paraphernalia. I mean, paraphernalia is, I know that the state stance on paraphernalia has changed significantly, so.
Right, the state would have no objection on the ROR.
Okay.
Can't confirm on the,
Yeah, well,
ETD.
be it what it may, the charge of paraphernalia has been viewed a little differently in recent years. So the court, without objection from the state on ROR, will go ahead and ROR you on this charge. I've appointed the Office of the Public Defender to represent you. Because it may be diversion eligible, a condition of your release is that you maintain maintain contact with your attorney, okay? So if they can't get in touch with you, it's not only gonna be, if you miss a court date, it's gonna be a failure to appear, but it's also gonna be a violation of your conditions of release. So make sure that you maintain good contact with your attorney, okay?
Sure.
All right, good luck to you. You too.
And Mr. Smith is going to be a plea, Your Honor.
Is this Mr. This is Smith?
Yes, Your Honor.
Mr. Chevelle Shepherd?
Not on the docket, Your Honor.
All right, 220-20802. 802, correct. All right, sir, what is your name?
Charles Smith.
All right, Mr. Smith, you're here on one count of trespass on property after warning. The court's, it's my understanding it's going to be a plea today. Is that what you want to do? All right. I did not appoint the Office of the Public Defender to represent you. It's going to save you about $50, but the attorney standing next to you, she is a friend of the court, going to answer any questions you might have about the plea form, okay? All right, sir, I was handed a plea form. You have a chance to go over this plea form with the attorney standing next to you?
Sir.
All right, you understand that by resolving your case here today, there's not going to be a trial and that you're waiving the rights associated with going to trial?
Yes, sir.
All right. Anyone threaten you or coerce you to enter this plea?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
Sir.
You understand by entering a plea to this offense, if you're not a U.S. citizen, it will subject you to deportation? Do you understand? You got to answer out loud, yes or no?
Yes, sir.
All right. Do you understand that if you were on probation for a separate offense, a plea to this offense might be used to violate that probation?
Yes, sir.
And do you understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
All right, we'll accept the no contest plea, adjudicate you guilty, assess court costs, we'll reduce those to a civil judgment. Sent you to 2 days in the Orange County Jail with credit for 2 days that you've already served. So you'll be released as to this charge today. We're also ordered that you do not return to the Wawa at 8574 South Orange Blossom Trail, okay? All right, good luck to you, sir.
Have a good one. You want to take it? Okay.
All right, sir, what is your name?
David Weldon.
All right, Mr. Weldon.
And Judge, I'm just going to quickly go over a plea form. He decided he would like to accept the plea, so.
Okay. Well, you're here on 2 counts. 1 count trespass on property after warning, 1 count of resisting an officer without violence. The attorney that's assigned to this courtroom has indicated it's your desire to plea here today. Is that correct?
Yes, sir.
All right.
And again, the offer from the state, Your Honor, was adjudication, time served, which would be 2 days in this case, and
On both
cost.
counts? He's got 1 count of trespass, 1 count of resisting.
What
So
was-
it's adjudication time served on both counts?
Yes, Your Honor.
All right.
Sorry.
And is there a no return as well?
No return.
All right.
As long as you don't have any other questions. Right there. Yep, as long as you're not being held on any other case, which I don't believe you are.
All right, Mr. Weldon, I was handed a plea form. Do you have a chance to go over this plea form with the attorney standing next to you?
Yes, sir.
All right, you know that by resolving your case here today that you're waiving the rights that are listed on this plea form and there's not going to be a trial?
Yes, sir.
You understand that if you're not a U.S. citizen, a plea to this offense would subject you to deportation?
Yes, sir.
Do you understand that if you're on probation for a separate offense, even if it's out-of-state probation, I'm not saying you are or you aren't, I'm just asking if you understand. Do you understand that if you are on probation for a separate offense, a plea to this offense might be used to violate that probation?
Yes.
All right.
I'm aware of that.
Do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes.
All right. Are you under the influence of any drugs, alcohol, or medications affecting your ability to understand what's happening here today?
No.
Has anyone threatened you or coerced you to enter this plea?
No. No, sir.
All right, so we'll accept the no contest plea. Count one will adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served plus court costs. I'll give you 1 year to pay the court costs or to be on a payment plan making regular payments. With regards to count two, we'll adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served, with no further sanction. So you should be released as it relates to this charge today, okay?
Thank you.
All right, good luck to you, sir. Davis, Eric Davis.
Yes. I can give you.
Have him as an out-of-county hold?
Yeah.
I just have out-of-county warrant, no bond, it's, okay. Well, I can't appoint the Office of the Public Defender to out-of-county. So, unless it's Osceola County, which is Polk County, okay.
Just need to reset them, Your Honor.
All right, so we will stay the bond at none for Mr. Davis. And then I had 2 county ordinances, Joshua Green, or 1. We already did Michael Taylor, correct? Yeah. I had Joshua Green, 220-20820. I'm sorry. It's 220-20820. All right. No, gotcha. All right, we'll go off the record. Thank you, everyone.
Good morning.
Good morning, Mr. Anderson. You're here on 1 count of burglary of an auto other than conveyance unoccupied. That has a $3,500 bond. You're also out on bond on 2 cases with similar offenses. Those bonds will remain at 0. Like I said, I'm going to appoint the Office of the Public Defender to represent you, okay?
Okay.
All right, thank you.
Your Honor, can I have
You have a nice day.
Your
Hold
Honor,
on.
can I get the case numbers for the bonds that are set at 0?
Yeah, it's 2022 CF77 and 2021 CF3590.
Thank you, Your Honor.
These are orange. Okay. Next I have Freddie Arroyo. Morning, Mr. Arroyo. You were here on and counsel, if you can mute your microphone again when you're not talking, we're just getting a lot of feedback. Thank you very much. All right, you're here on a warrant. Give me 1 second. So a probable cause determination's already been made on the count of battery and hindering written communication to a law enforcement officer. With regards to count 1, the court's going to set bond at $1,000. Conditions that you have no contact with the alleged victim, that you possess no weapons, firearms, ammunition, any weapons whatsoever. And do you and the alleged victim, you can talk to, I'll appoint the Office of the Public Defender to represent you so you can tell your attorney, do you and the alleged victim reside together?
Just one moment, Your Honor. They do reside together, Your Honor.
All right, I'm going to order you, do not return to the residence, but I will allow you to return to the residence one time under the accompaniment of law enforcement to get any personal belongings. Then you got to stay somewhere else until further order of the court. You understand? All right. All right. Anything further, counsel?
No, Your Honor, thank you.
All right, thank you. Who was that? Was that Freddie Arroyo?
Freddie, yeah, he showed up to.
Oh, Mr. Arroyo had a second case, sorry. He had a operating a vehicle without a valid driver's license. We're 500? Yeah, stay count 2. And then on the operation of motor vehicle without a valid driver's license, court does find there's probable cause, set bond in that case at $100. Thank you. All right, Emilia's Brialis Neves. Thank you. All right, ma'am, you're here on one count of battery, touch, or strike. It came in as no bond. The court's reviewed the affidavit, does find there's probable cause. We'll appoint the Office of the Public Defender to represent you. Order that you have no contact with the alleged victim in this case. Order that you do not return to the residence. If you live together, you can return to the residence one time under the accompaniment of law enforcement to retrieve any personal belongings, and you got to go somewhere else until further order of the court. Also going to order that you possess no weapons, firearms, ammunition. If you have any of those things, that you surrender those to law enforcement within 24 hours of your release. Anything further?
What was the monetary amount, Your Honor?
500?
Thank you, Your Honor.
Uh-huh. All right, next I have Yasel Cabrera.
Yes, sir.
All right, Mr. Cabrera, you're here on one count of trespass property after warning. I've reviewed the affidavit, do find there is probable cause. I'm going to set bond in this case. I'm going to ROR you, just require you do not return to the McDonald's where this was alleged to have occurred. If you return to the McDonald's, it'll be a violation of your conditions of your release, and there's a chance you might be held no bond, okay?
Thank you, Your Honor.
All right. And if I didn't, I'll appoint the Office of Public Defender to represent him as well. Sergio Carrasquillo. Sir, what's your name?
Sergio Carrasquillo.
All right, sir. You're here on one count of battery, touch, or strike. I do reviewed the affidavit, do find there is probable cause. Set bond in your case. $1,000. Or do you have no contact with the alleged victim? Do not return to the residence. I will allow you to return to the residence one time under the accompaniment of law enforcement. Also order that you consume no alcohol and that you do not possess any weapons, firearms, ammunition. Also appoint the Office of the Public Defender to represent you. Thank you, sir.
Thank you.
Next I have, came in as a Jane Doe. I believe she was determined to be,
Your Honor, she does require the services of a Spanish interpreter.
okay. How many require the services of this? All right, she does need an interpreter?
Yes, Your Honor.
All right, how many need an interpreter?
One moment, Your Honor.
Yeah.
Three more, Your Honor.
All right, thank you. Okay, call them. What are the names of the other individuals? While we're waiting for the interpreter to join, I'm going to pull their affidavits.
One moment, Your Honor.
Okay. We do that on the black box, right? The interpreter? It's not connecting for whatever reason. Okay.
Your Honor, it's actually just two. It's Jose Rivera Ortiz and Alan Salgado Rios.
All right. Jose Rivera Ortiz was one you said?
Yes, Your Honor.
And Alan Salgado Rios. Okay, I got that. All right.
Hello, Cisco Unity Connection Messaging System. From a touch-tone telephone, you may dial an extension at any time. For a directory of extensions, press 4. Otherwise, please hold to leave a general message.
I just want to end that one call, though.
Sorry, there is no operator available at this hour. Record your message at the tone. When you are finished, hang up or press pound for more options.
Let's go ahead and pass the interpreter cases. We'll try to call them at the end. I don't know if they overslept or what. So.
Yes, Your Honor. Thank you.
Okay. All right. All right. If I hang up on you, Osceola, I'm going to call you right back because I don't know how to end the interpreter call without. Hold on. Let me try to figure this out. I did it. Okay. All right, next I have Tyvon Evans.
Pierre Evans, Your Honor.
Oh, yeah, Pierre Evans, sorry.
Your Honor, he has refused. If we could reset.
Okay. We'll appoint the Office of the Public Defender to represent Mr. Evans. We'll reset that until tomorrow.
Thank you, Your Honor.
David Garcia. All right, Mr. Garcia, you're here on one count of possession of controlled substance without a prescription, one count of possession of drug equipment. Appoint the Office of the Public Defender to represent you. Counsel, is the drug equipment, is that the baggie?
Yes, Your Honor.
Okay.
And he is eligible for direct PTR on both of these charges?
All right. All right. Well, if he's eligible for PTR on both of those, we'll order him released on PTR. Yeah, no special other conditions other than the normal PTR conditions, okay?
Thank you, Your Honor.
Your Honor, there is a second case, I believe.
What's that?
I believe there's a second case for this defendant.
David Garcia, oh,
He is also eligible for direct PTR for that one as well.
that's sure I'm while license suspended. Okay, we'll release him on PTR on that charge as well. Next, Idris, or Ranjeesh Hamilton. All right, Mr. Hamilton, you're here on one count of battery. Touch your strike. Appoint the Office of the Public Defender to represent you. We'll set bond in your case at $1,000. Or do you have no contact with any of the alleged victims? You do not return to the residence. If you need to return to the residence to get any personal belongings, you may do so, but only in the presence of law enforcement. Also, order that you possess no weapons or ammunition. Thank you, sir.
Your Honor, this is Officer Henderson with pretrial release. If I may go back to Yesel Cabrera.
Yes.
Okay, he's out on ROR on 2 cases out of Osceola County, 22 MM 1431 and 22 MM 1128, both trespassing. Your Honor, will there be no action on those 2 cases?
Those are the ones we revoked the bond, correct, counsel, and set at 0?
No, Your Honor.
No?
You just placed him on ROR on this newest trespassing.
Oh, okay. I was thinking of someone else. Yeah, we're going to take no action on those.
Thank you, Your Honor.
What were the case numbers again?
22 MM 1431, 22 MM 1128.
And they're Osceola County cases?
That is correct.
All right, thank you.
You're welcome. Thank you.
We did, hold on one second. Here's those, I don't know if we need those. Those are people we've already called. One second. She's Spanish. Those other ones. I don't know if you need those or not. That's all right. Eliza Loreno.
Your Honor, Corrections is asked if we can bring him up last. He is in like quarantine of some sort.
Okay. Michael Morales. All right, Mr. Morales, you're here on one count of battery, simple battery, domestic in nature. Reviewed the affidavit, do find there is probable cause. I'm going to set bond at $500. Require that you have no contact with the alleged victim, that you do not possess any weapons, and that you do not return to the residence without further order of the court. I'm allowing you to return to the residence one time under the accompaniment of law enforcement to get any personal belongings. Then you got to stay somewhere else until that order gets modified, or if it does, okay? I'm also going to order that you consume no alcohol as a condition of your bond. All right, thank you, sir. Okay. Charles Napier. All right, sir, you're here one count of domestic battery by strangulation. The court's reviewed the affidavit, does find there is probable cause. Court's going to set your bond at $1,000. Require that you have no contact with the alleged victim. Do not possess any weapons. Do not return to the residence where this was alleged to have occurred. If you need to return to the residence to get any personal belongings, you may do so one time under the accompaniment of law enforcement. One time only. All right, thank you, sir. I'll also appoint the Office of the Public Defender to represent you.
Your Honor, is the 1,000 for just a domestic one? He has a trespass on property as well.
Well, I didn't see that. What?
I don't have that.
I didn't have that one either. If it's in his paperwork, I'll be a nominal bond of $100. If I don't have it, we don't have it. We don't have that charge. All right.
Thank you, Your Honor.
Also got William Mora.
He is present and approaching.
All right. All right, Mr. Mora. You're here on a warrant for violation of probation, came in on no bond. Court's going to stay the bond that was in the warrant at none until further order of the court. Was there any other conditions on the warrant? I didn't see. No. Okay. Thank you, sir. I'll appoint the Office of the Public Defender to represent you.
Thank you, Your Honor.
Ahmad Nasir. All right, Mr. Nasir, you're here one count of kidnap, false imprisonment, battery, touch, or strike. That was pursuant to a warrant, so a probable cause determination's been previously made. Court's going to set bond on count 1 at $1,000, count 2 at $250. Special conditions that you have no contact with the alleged victim. Do not return to the residence where this was alleged to have occurred. If you need to return one time with the presence of law enforcement, you may do so one time only. Also, order that you possess no weapons, firearms, ammunition. And if I haven't done so already, I'll appoint the Office of the Public Defender to represent you. Okay? Thank you.
Thank you, Your Honor.
Yep. Leonardo Nunez.
Your Honor, he has posted bond.
All right. Alan Smith. All right, Mr. Smith, you're here one count of simple battery, one count of petty theft or retail theft. I've reviewed the affidavit. Do find there's probable cause within the affidavit. I'm going to set bond on count 1 at $500, count 2 at $100. Order that you do not return to the CVS where this was alleged to. It was a CVS. I'm appointing the Office of the Public Defender to represent you, and order that you do not return to the CVS where this was alleged to occur. Okay. All right. Thank you, sir. Kisel Vargas Cespedes.
My apologies, Your Honor. Can we reset this for tomorrow? He has refused.
All right, we'll appoint the Office of the Public Defender to represent Mr. Vargas Cespedes, and we'll reset that till tomorrow.
Thank you.
Tyrion Wesley. He has 2 cases. All right, Mr. Wesley, you have 2 cases. One is 3 counts, 1 count of petty theft, 1 count of simple battery, 1 count of resist recovery of merchandise. The court's reviewed the affidavit in that case, does find there's probable cause as to each count. I'll appoint the Office of the Public Defender to represent you. On the battery, you set bond at $500. We'll set bond at $100 on the other 2 offenses. Special condition, you do not return to the Walmart where this was alleged to have occurred. On the second case, it's 1 count of petty theft from August 6, 2022. The court's reviewed the affidavit, does find there's probable cause. will set bond in that case of $100. Same conditions, you do not return to the Walmart where that was alleged to have occurred. I'll appoint the Office of the Public Defender to represent you in that case as well. Thank you, sir. Dustin Wiggins. All right, Mr. Wiggins, you also have two cases. The first case has 4 counts. 1 count of burglary of an unoccupied vehicle, 1 count of criminal mischief, 1 count of petty theft, first offense, 1 count of resisting an officer without violence. Court's reviewed the affidavit in each case. Specific to the 4 counts, court finds probable cause as to each count. On the burglary, will set bond at $3,500. Will set bond at $250 on the criminal mischief, $100 on the petty theft, and $100 on the resisting. We'll appoint the Office of the Public Defender to represent you in that case. You also have a second case of 3 counts, credit card fraud, more than $100, possess an ID without consent, and theft of a credit card with intent to use. Court finds probable cause in that case as well. On the possession of an ID without consent, the court's going to set bond at $1,000. Set bond at $100 on the other 2 charges in that case. We'll appoint the Office of the Public Defender to represent you in that case as well. Thank you, sir. All right, Edward Zelby.
He is present and approaching. Your Honor, are you taking pleas today?
I will be happy to.
Would the state be amenable to a AG credit time served, reduced costs to judgment?
It's a panhandling charge, state.
State's fine with that.
All right.
Forgot all my words.
Okay.
Your Honor, we have previously prepared a plea form that Mr. Zebley has read and signed and are ready to proceed.
All right, sir. What's your name?
Edward Zebley.
All right, Mr. Zebley, you've heard what the attorney there has had to say. Is that your understanding what you want to do here today?
Yes, sir.
All right, the attorney that's in the room there, I haven't appointed her to represent you. It's going to save you about $50, but did you have the opportunity to speak with her as a friend of the court regarding the plea form?
Yes, sir. Yes, sir.
All right, you understand that by resolving your case here today, there's not going to be a trial and that you're waiving the rights associated with going to trial?
Oh, yes, sir.
All right, you understand that if you're not on, or that if you are on probation for a separate offense, a plea to this offense might be used to violate that probation?
I'm not on probation, sir.
Yeah, just asking if you understand that. Do you understand?
Yeah, yes, sir. Yes, sir.
All right, do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could be used to subject you to involuntary civil commitment?
I understand, sir.
Understand if you're not a U.S. citizen, a plea to this offense would subject you to deportation.
I'm a citizen. I'm an Indian, so I ain't got that part to worry about.
Okay. You're under the influence of any drugs, alcohol, medications affecting your ability to understand what's happening here today?
Oh, no, sir. None.
All right, well, accept the plea of no contest, adjudicate you guilty. What does he have, 1 day?
Two.
Yes, Your Honor, I believe so.
All right, well, adjudicate you guilty, sends you to credit for time served. You'll be released as it relates to this charge today. The financial obligations will reduce to a civil judgment.
All right, thank you, sir.
All right, anything further?
Your Honor, what was the case number for the plea form?
I have 20. There is no case number yet.
Perfect, thank you.
Thank you.
Your Honor, I do believe it's 2 days.
All right, so we have him as 2 days. We're sentencing him to 2 days with credit for 2.
Perfect, thank you.
Samantha Martin. Sorry that I hadn't given you those. That's just a stack. All right, Miss Martin, you came here on Allen County warrant. The bond in that warrant's $2,000. We're going to stay the bond at $2,000 in your case, okay? All right, thank you.
Thank you, Your Honor.
All right, next I have Christine Beck. All right, Ms. Beck, you have 4 cases. First case I have is driving while license suspended or revoked. Court's reviewed the affidavit in that case, does find there's probable cause, will set bond in that case of $250. I'm also going to appoint the Office of the Public Defender to represent you. Second case is battery on a law enforcement officer, fighter, or intake official, and resisting an officer with violence. Court's reviewed the arrest affidavit in that case, does find there's probable cause for each. Will set stay the bond on count 1 at $2,500. Set bond on count 2 of $100. Appoint the Office of the Public Defender to represent you in that case as well. Next case I have is 3 counts: possession of a controlled substance without prescription, possession of use of drug paraphernalia, possession of, and another count of possession of controlled substance without a prescription. Set bond on count 1 at $500 and $100 on counts 2 and count 3. Appoint the Office of the Public Defender to represent you on that case. Do we know why? The next one I have is grand theft auto, grand theft greater than 10,000, burglary of a structure, unarmed, burglary of an unoccupied vehicle. I'll appoint the Office of the Public Defender to represent you in that case. The bonds in that are set at none. Is there a reason why those are set at none that I don't know about?
I believe some of these do require
First.
bond conditions because of like no contact and things like that, Your Honor.
Okay. All right. Well, the court's reviewed the affidavit. Does find probable cause as it relates to each count. We'll set bond on count 1 at $1,000 and $100 on the remaining counts. Special condition of bond no return to the Comfort Inn and Suites located at 2775 Florida Plaza Boulevard in Kissimmee. You're also out on bond in 2022 CF 1693. That was a vehicle theft case. The court's going to revoke bond in that case and set it at none, and appoint the Office of the Public Defender to represent you in that case as well. All right. Thank you, ma'am.
Thank you, Your Honor.
All right. Let's try to call the interpreter again.
Good morning, Your Honor. This is Laura Royo, State Certified Interpreter.
I'm sorry, Madam Interpreter, you broke up. Have you been sworn?
No, I have not been sworn this morning yet.
All right, well, go ahead and raise your right hand to be sworn. All right, do you promise to translate from Spanish to English, English to Spanish, the testimony you're here today to the best of your ability?
Yes, Laura Royo, State Certified Interpreter.
All right. Oh, that's another one for her. Hold on, did I give you? I think I gave you face sheets for the Spanish. All right, let's start with She came in as a Jane Doe. Her name is Kellerin Yasmin. Thank you. All right, she is at the podium. Madam Interpreter, I don't think we have a case number yet. All right, ma'am, you're here on one count of retail theft.
Muy bien, señora. Usted se encuentra aquí por un cargo de ratería en tienda.
The court's reviewed the charging affidavit and does find there's probable cause.
Este juzgado ha estudiado la affidavit de arresto y determina que existe indicios razonables.
Court's going to appoint the Office of the Public Defender to represent you.
Se le designa en este juzgado a la Oficina de Defensores Públicos para que le representen.
It's going to set bond at $100
La fianza se fijará en $100
in order that you do not return to the Walmart where this was alleged to have occurred.
y se le prohíbe a usted regresar al Walmart donde supuestamente esto ocurrió.
All right, thank you, ma'am.
Gracias, señora.
Yes.
If defense may be heard, she would, based upon the offense, be eligible for direct PTR, but there's an issue with immigration, so she's not. Defense would ask that she be placed on ROR.
Su señoría, según con lo que consta aquí, ella cualifica para poder ser concedida libertad provisional, pero si no es así, pedimos que se le conceda caución juratoria.
All right, the court will grant the request, place her on ROR, given those circumstances. Condition that she not return to Walmart remains a condition of her ROR.
Muy bien, entonces basado en ello se le concede la caución juratoria y como condición de esta caución usted estará prohibida regresar al Walmart.
All right, thank you, ma'am.
Gracias, señora.
All right, Mr. Rivera Ortiz. All right, Mr. Rivera Ortiz, you're here on one count of driving under the influence.
Muy bien, señor Rivera Ortiz, usted se encuentra aquí por un cargo de conducir bajo los efectos.
Court's reviewed the arrest affidavit, does find there's probable cause.
Este juzgado ha estudiado el affidavit de arresto y determina que existen indicios suficientes de criminalidad.
I'm going to appoint the Office of the Public Defender to represent you.
Se le designa a la Oficina de Defensores Públicos para que le representen a usted.
I'm going to stay the bond at $500.
Y se mantendrá la fianza en $500. Su señoría, él reúne los suficientes requisitos para libertad provisional directa.
All right, I do see that now. We will order him to be released on PTR.
Muy bien, sí lo veo. Así que se ordena que él sea concedido libertad bajo el programa de libertad provisional.
Thank you, sir.
Gracias, señor.
Next, I have Alan Salgado Rios.
He is present and approaching, Your Honor, and for the court's information, he is also eligible for direct PTR.
Thank you for that.
Good morning.
Su señoría, él está aquí, se está acercando y para que sepa su señoría, él también reúne los suficientes requisitos para el programa directo de libertad provisional.
All right, Mr. Salgado Rivas, that good morning sounded pretty good. Do you understand English? Do we need the interpreter? Can we let her go?
I have some trouble with some words, so I'd rather have her.
Okay.
So I like to, understand fully, completely what I'm.
Okay. All right, so you're here on one count of possession of cocaine, one count of possession of drug paraphernalia.
Muy bien, señor. Se encuentra usted aquí por un cargo de tenencia de cocaína y un cargo de tenencia de adminículos de drogas.
The court's reviewed the affidavit, does find there's probable cause and that you qualify for pretrial release.
Este juzgado ha estudiado el affidavit de arresto y se determina que existe indicios suficientes de criminalidad y además que usted reúne los requisitos para el programa de libertad provisional.
I'm going to appoint the Office of the Public Defender to represent you. And we'll release
Se le va
you on PTR.
Se le va a designar la oficinas de defensores públicos para que le representen a usted y se le concederá la libertad bajo el programa de libertad provisional.
Thank you, sir.
Gracias, señor.
Thank you.
Thank you.
All right, Madam Interpreter, we're all set. We may call you back pretty soon. We got one more in Osceola, and then we'll start here in Orange County, but you're excused for now.
Yes, thank you, Your Honor.
All right, thank you.
And Judge, for the court's information, we have
We're here on Eliza Loriano. All right, Mr. Loriano, you're here on one count of battery, simple battery, and one count of contributing to the delinquency of the minor. Counsel, could you mute the microphone real quick? Thank you. One count of battery, simple battery, one count of contributing to the delinquency of the minor. The battery is domestic in nature. Reviewed the affidavit. Do find there's probable causes to both counts. I do review staff notes that the alleged victim, I believe, is your mother, does want contact and wants you to return home if you can abide by the rules, is what the note said. That's not my words, that's your mom's words, okay? Court's gonna ROR you, require that you have no contact with, no hostile contact with your mother or any of your siblings or anyone else that's living in the house. I'm also going to order that you possess and consume no illegal drugs without a valid prescription. That includes cannabis. You're 18 years old now. You start playing adult games, you win adult prizes, okay? So you're getting the chance to go back home and start playing by the rules a little bit, okay? Well, I'm going to let you go without posting a bond, but there are going to be some conditions, which I've told you. No hostile contact, no fighting with your mom or your siblings or anybody else that's living in the house. No drugs, and no weapons. You understand?
Yes, sir.
All right. All right, and I'll also appoint the Office of the Public Defender to represent you. Is there anything further, counsel? All right, and so we're done in Osceola, correct?
Yes, sir. See you tomorrow.
See you tomorrow. Thank you.